Well, good afternoon. Appreciate you guys staying around and digging into the subject matter today. It's not something that is necessarily easy to talk about. And so we'll try to navigate it as fun as we can make it. I mean, we are dealing with somewhat of a sober subject, as it were. And so we'll be respectful of that. But a couple things today before we get started. Firstly, the session today is meant to be interactive, okay? If you have questions, please get my attention, whether that means you have to raise your hand, whether you have to jump up and down, scream, whatever you have to do. Those of you who are way in the back must previously have been Baptist. Might be good to move forward. You're welcome to stay. That's where I would sit, honestly. But to interact and to just kind of learn from each other. There's experiences that some of us will have had that others will not have, and we can learn from each other. A little bit about myself, a little bit of history, and about Church Extension Plan. I'm married, have two daughters, both grown, both married. One chose to live on the East Coast, one chose to live on the West Coast, and I live in Colorado. So we have this ongoing conflict, about where do we, when mom and dad retire, where are they going to retire? And it's turned out to be that it's not which one of us which one of the daughters gets us. Which one has to take us? It becomes the discussion. No grandkids yet. Our oldest has been married 5 years, I think. Our youngest just got married last November. And our youngest was in Colorado Springs. She gets married and promptly moves to Oregon. I don't know if that says something about us. They were in an awful hurry to get out of Colorado. Why anybody would leave Colorado, we're trying to, figure that part out. I grew up as a missionary kid. My parents served with World Vision for a number of years. Grew up in Kenya, and so I have deep African roots, went overseas when I was 6, and graduated from high school there, came back, and I did my undergrad studies up in British Columbia, and got my MBA in Colorado at the University of Colorado. And then, as Pastor introduced me this morning, got my certified financial planner a few years ago. But I've been doing this kind of work, essentially estate planning with a charitable focus for nearly 30 years. Different organizations, different locations, but serving the Lord in the way that He has brought me, and it's been a joy to be able to do this. And Church Extension Plan, we are a financial ministry within the Assemblies of God. And we offer financial services to the churches and to the ministries within the fellowship. And one of the things that our primary focus really is around financing for ministries that are looking to purchase a property, are looking to expand their property, looking to remodel their property. We get the pleasure of coming alongside them and providing that financing. In your packet should be a card that looks like this. And in order to provide that financing, we have people like yourselves who invest with us, and we offer essentially what are called promissory notes. They're very much like a bank CD, although this is being recorded, and so technically I'm not allowed to say that. But that's the way they operate. They're essentially a term deposit where you invest money for a length of time and you receive interest on that investment. If you're looking for a way to put some funds aside for retirement, you're putting some funds away for maybe a child's future education, just general savings, this might be a great way to do it. what better way to invest and know where your dollars are being used? When you use other investments and other avenues that are out there in the world these days, you don't always know where your funds are going. And so we would just like you to consider coming alongside, being a partner with Church Extension Plan. We provide loans here in Indiana, and so if you'd like to do that, that's that card. You can fill that out today, leave it with me. I'll take it back to the office, make sure some information is sent to you, and so on. One other quick thing in your packet is this little card right here. If you would, please, take a moment today, fill out your name and address, and questions 1 and 2 in particular on here are important for us. If you would do that today after, during the session, drop it with me afterwards. You can just leave it up here on the front steps or leave it on your chair. We'll get it collected. And then question 3 and 4, if you are brave and want to leave that with your name, I promise if you say something bad that I will come after you. No, seriously, I do like the feedback. It helps us, helps me know kind of where I need to make changes and make adjustments to the presentation. So if you would fill that out, please, please, please leave that, and that would be greatly appreciated. All right, we're going to navigate, like I said, a couple hours, hopefully not quite that long, of some information, but I want to give us a baseline to start with today that really is scripturally based, okay? A foundation on which we want to think about this subject matter. Because there are all sorts of reasons for doing your estate plan, for preparing for ultimately when we pass on what happens with our stuff. And we just want to make sure that we have the right reasons for doing things, okay? We all have different goals, different reasons, different responsibilities. And doing our estate plan, there may be things that you need to take care of. You need to take care of young children. Maybe you have goals for ministry. Maybe you just have grown children that you need to care for. There are lots of reasons for that as well. But we want to ground that in really considering what Scripture tells us. And so, okay, there we go. We want to start today with who owns what we have, right? We know that the world is going to tell us that, go out and make your money, go out and make your mark. It's yours. You've done all the work. You need to own it. You have it. And yet Scripture tells us what? God owns it all, right? God owns the cattle on 1,000 hills, okay? Or is it 1,000 cattle on a hill? No, cattle on 1,000 hills, okay? So we need to just recognize God's ownership. And while there's no necessarily wrong or right way in how we design our estate plan around that concept, we just need to understand that we have certain responsibilities, okay? And the stewardship of what we have and what God has entrusted to us is important, and we need to take that into consideration, okay? The more we have, the happier we're going to be, right? Go out and make money, all right? There was actually a study done not too long ago that took that whole concept and said, okay, is earning more money, does that actually make us happier? And there was this sense of up to a point, maybe, okay? But after that, more money just didn't mean anything, all right? There's a certain level at which having assets, having money does provide us with certain things, but it doesn't necessarily make us happy. Our joy comes from the Lord and from being able to use the assets for His glory, to be able to use what He's given to us for others and to be able to give, right? So again, trying to think through, okay, do I need to go chase that dollar, or do I say, Lord, I've got enough. Tell me how to use that appropriately. Next, the world's going to tell us the more we pass on, the better it is for our heirs. Okay? And we want to take care of our children. We want to take care of those that we're responsible for. But there comes a time, there comes a place at which maybe an inheritance is not the right thing. Okay? A child who maybe can't manage money very well, or who has, shall we say, certain issues, that handing them a pot of money is just going to cause them to go off the rails and really lead them in a path that just isn't good. Okay? So we want to just be real careful and understand and properly think out what is it that that God is telling us, and how do we leave that appropriately for our heirs. And then finally, we think, okay, accumulating stuff is just the ultimate end goal, right? Kind of goes along with the more we have, the happier we'll be, all right? Think of the rich ruler in Scripture, which is the Scripture reference, who gathers in all of his harvest. Anybody here in farming? You have farming a little bit? Okay. And you gather in the harvest, and you put it all in your silo, and you say, I've got it all, and I'm going to put my feet up and rest and not have to worry about anything anymore. And God says, your focus is misplaced, you fool. And you know, his life is taken. It's just gone. And what has he had? What has he done with his stuff? Ultimately, nothing. Okay? So our focus needs to be on what is God telling us? How do we manage what He's given to us? How do we deal appropriately with ultimately what is His? We're going to cover basically 4 areas today. We're going to talk about people. Obviously, estate planning is wrapped around those that we care for. It's wrapped around understanding who is important in our lives. We're going to talk a little bit about goals. How are we going to set goals that are appropriate dealing with the people that are in our lives as well? And we're going to talk about property. And we're going to spend a little bit of time in the property section. Especially talking about how property is owned, structuring ownership can be an important way of leaving assets to family members or to ministry. And then we're going to walk through 4 different kind of what I call the basic, well, really 3 of them are the basic estate plans, okay? The ones that will cover 99% of the people. And then the 4th one is a unique one. I alluded to it this morning with the couple who did their estate plan that took care of kids and then left money to ministry. Okay? And I'm going to show you a way that you can do a very similar process. Doesn't take huge assets. The calculation works whether your estate is really large or really small. It's just a way of setting up your estate so that you can care for family and care for ministry. We'll also talk a little bit today about some unique giving methods that are, I wouldn't say they're outside of the estate planning process. They're kind of next to it, okay, and beside it. There's some ways that you can deal with your estate and make some special gifts to ministry as well. So we'll deal with those. Let's look at the goals first, okay? You all have a reason that you're here, right? Anybody want to share, why are you here? Somebody. Sir. don't have anything yet, okay? So we need to figure that out. Anybody else? Yes, sir. Estate planning, okay? Just trying to organize it, do it appropriately, and so on, okay? If you were to have some goals for your estate, okay, these are probably the ones that you're going to wrap your estate around, okay? You want to leave income for your family, right? You want to try to figure out, okay, how do I care for the loved ones in my life? Maybe you want to leave money to ministry, all right? How do I do that appropriately? What does that look like? How do I remember the church and do something special with what God has entrusted to me? Maybe I'm worried about probate costs, okay? There's an expense to probate, and we want to make sure that we deal with that appropriately. And we just want to be efficient with it, okay? So all of those goals are kind of normal. They're the common ones. And so we'll look at the way to do some of those things. Let's talk a little bit about people, your immediate people, okay? Your family and so on. This is the information, as you work with your attorney, this is the information that is going to be important to you and important to your attorney. In your packet, there is a booklet that we have put together. It's an estate planning, will planning workbook. This is where you can record everything that you will need to record in order to be able to do, to work with your attorney to do an estate plan, okay? This serves as really two purposes. The first purpose is, like I said, to work with your attorney. The second purpose is when you select your executor, this becomes their roadmap, all right? As you look at the workbook, you'll notice there's a place to record your assets. Where do you own? Where is it? What kind of assets are there? What debts do you have? And so on. If you were to pass away today, who would know where all your bank accounts are? Okay? Who would know where your investment accounts are? All right? So this becomes the roadmap for your executor to be able to settle your estate, because they need to wrap their hands around the financial assets and any real property, your real estate and any other things that you own. And they have to be able to know where that is, know how it's owned, and deal with it, okay? So it serves two purposes. And you're going to record your personal family information in that as well. Important information is things like birth dates, where they live, proper legal names, okay? I used to do this in the South, right? Meemaw doesn't quite cut it, you know. Bubba is not a legal name for most people, so you want to record legal names and make sure that you have that data recorded, because as your executor reaches out and tries to find people, they need to be able to do searches to be able to find that individual. I was talking to a lady just a few weeks ago. I did the presentation in Oregon for a church there, and she came up to me afterwards, and she has a situation, and her son has been estranged from the family for some time. And she is trying to locate him, and she thinks she has a Social Security number for him, but she doesn't know. She has this random Social Security number recorded somewhere that is attached to his name, but she's not confident it's his, and he's been out of the picture for some time. She doesn't. About 3 years ago, she knew he lived in California someplace, but he's gone missing, essentially. So one of the things that needs to happen for her in this estate settlement process, ultimately, is that, you know, she's got to be able to link him up and find him. So recording all of that information becomes important, and that book will certainly help you do that. All right, who are the important designees? Now, these are the people who are going to be ultimately involved in your estate. You're going to have your executor. He or she is going to be the key individual, and that individual needs to be somebody who's going to have some time, and we'll get into their role in a little bit. So you want to make sure of a good selection for your executor. If you have kids, who in here has minor children, okay, that you're responsible for? Okay. You're going to need to name a guardian, right? What happens if you and your spouse pass today? Okay, what's going to happen with the kids? All right, so you want to make sure that you name a guardian. You may need a trustee. If you're setting up a trust of some kind, you're going to need to know, going to need to designate who's going to manage that trust, who's going to manage the assets in that trust. You're going to need a financial power of attorney. All right, this is the individual who steps in essentially on your behalf should you be incapacitated, not dead, just incapacitated, and can't conduct business, all right, can't pay bills, can't write checks, can't, do all of that stuff. You're going to need a financial power of attorney to do that for you. You're also going to need a medical power of attorney. All right, this is the person that makes medical decisions for you. Again, if you're incapacitated, can't speak, can't let your wishes be known, who is that individual? All right? My parents, my dad just passed away last September. My parents were, he was 80, my mom was 80. They had done their estate and set everything up, and they communicated and so on. They were very wise. I and my brother live in Colorado Springs, where my parents live, and very wisely, they designated my brother as the medical power of attorney, and they designated me as the financial power of attorney. There's a very real reason for that is my brother has empathy, I do not. Okay? So dealing with the medical stuff, I'd probably say, pull the plug. Oh, this is being recorded, isn't it? Oops. Sorry, Mom. But in reality, we do have different personalities, okay? And my brother is used to dealing with the medical stuff with my parents, and I deal with the financial stuff. So your choice of those roles is important, and take into consideration the individual that you're considering, because they need to be able to deal with those situations. And honestly, the medical stuff we learned through my dad's passing, those aren't easy, okay? Anybody who's dealt with a parent or a sibling, a child, who's had medical issues that leads into death it's not an easy process. So those choices are really important. Okay, let's look at duties of an executor. The executor, remember, is the one who's going to settle your estate. And they're the person who really is going to rely on this book that you're putting together that says, okay, I've got to collect all of the assets. I've got to figure out where all the bank accounts are, where all the investment accounts are, and so on. Okay? They then, file the appropriate paperwork with the state. They're told, okay, you're now the official executor. They have to do the accounting. They have to do all of the paperwork with the state. They sell off the assets. They pay any final debts that come about. Then they close the estate, and they make the distributions. All right? Sounds like a fun role, right? Who's been an executor? Anybody? Aha, we have a few. Anybody want to share kind of how their process went? Don't do it. Okay. Very stressful. How long did it take? 2 years. Okay. At least it wasn't Prince's and it took 6. At least it wasn't Prince's estate that I alluded to this morning and took 6. Yeah. Of course, he didn't have any documents anyway, so that didn't help. So anybody else? Okay, what was the hardest thing about the estate? Being fair. Okay. So was there a will? Was there a will?
There was a will, but it wasn't exactly to the point of
Okay, so kind of a vague will that didn't.
very old.
Yeah, very old. Okay. So for those of you who might have an old document, this is a good reason to think about, okay, maybe I need to revisit it and see if it still does what I originally intended. Okay? People will pass away, they will move, relationships change, family situations change, so it's always good to revisit that. Especially if you've got real estate. Okay. Yeah, every 5 is kind of a good rule of thumb. I usually say if there's a life event, take a look, okay? What makes a life event? Birth of a child, marriage of a child, birth of a grandchild, relocation, okay? If you change states, state rules change, so it's always good to look at your estate plan, see if it's still valid, okay? All of those, kind of situations may, prompt a review of your situation. So good. All right. So what is probate? Okay. Well, probate is basically the process that the executor goes through. All right. File an application to serve as the executor. Essentially, you're notifying the probate court that you're the executor and they have to approve you. Usually if the will says so-and-so is going to be my executor, boom, stamped, and we move on. Unless there's some kind of challenge, all right? So you have to notify anybody who's going to inherit, anybody who's going to be owed something under the estate. So you notify those individuals. And basically, a notification most often can suffice in the local newspaper. I mean, you just publish a notice and say, so-and-so has passed away. Any creditors step forward, send your bills. You have 30 days, 60 days, 90 days, depends on what the state rule is. All right? So you go through that process, and you get those people paid off. We'll talk a little bit about property here coming up, but essentially, debt is a piece of your property. All right, so you have to notify all of those who have a beneficial interest under the estate. You gather all of the assets together, all right? Usually what happens is the executor goes to the bank, they produce a copy of the will, notification, the death certificate, and they liquidate the various assets, and they create an estate checking account, all right? And everything gets dropped into that estate checking account. All right? And then you pay off the creditors, and you file an estate return that says here's the accounting. The court blesses it, and you do your distributions. All right? Now, travel with me in your mind, if you will. If you have real estate here in Indiana, and you have real estate just up north in Illinois, and you have real estate over in Florida or somewhere else, think about how difficult that process starts to become, okay? Because all of those pieces of property and so on have to get sold. The point I'm making is your executor needs to be somebody who has time, because they have to deal with these pieces of real estate, and that's usually what ties up an estate in terms of its length, all right, is taking time to get the real estate sold. That process, can take anywhere from 30 days or less in a really hot real estate market to 6 months, a year, depending on the piece of real estate, all right? So it needs to be somebody who has that time. So keep that in mind if you think back to what the executor role is. Keep that in mind because that needs to be a big part of your consideration. All right, typical probate fees. These are actually the typical probate fees for here in Indiana. You guys actually are reasonably inexpensive. On the other hand, who wants to pay 6% of the first $100,000 of assets? Okay, if you don't have to. 6%, there goes $6,000 out the door. All right? So what we want to try to do is make sure that we're minimizing those probate costs. We're setting up our estate in a way that shrinks that down to make those costs pretty minimal. All right? Most states, and I believe Indiana is this way, most states have what they call a small estate settlement process. So if your assets are under a certain level, and by assets I mean your probatable assets, and we'll talk a little bit about that in a minute, but your probatable assets are the ones that go through probate. If you keep that under a certain amount, the estate settlement is very, very small, okay? So it's good to look that number up and make sure that you understand kind of where that is. If you set your estate properly with good ownership, you can often avoid most of those costs anyway. Yes, sir? Does a trust help alleviate that? Yes. Okay? One of the great advantages, in which we'll get to, is that a trust, a revocable trust, totally avoids probate. All right? So all of your assets that are in a trust are not counted as part of the probatable estate. Okay? And we'll get to that because we'll be talking about a revocable trust. All right? Any other questions about this so far? Good. And most of you are still awake. That's good. All right. So let's talk a little bit about property. What is your property? All right. Well, obviously, your property is your real estate. Okay. You've got a home, maybe a second home somewhere. You might have land somewhere. Maybe it might have a farm. All of that is property, obviously. Checking accounts, savings accounts, investment accounts, retirement accounts, all of those financial assets are part of your property. They all have a settlement process. And then personal property is those items in your home. Typically, things like your fancy china, maybe your fishing rod collection, if you're into that kind of thing. I was a great disappointment to my dad, okay? My dad was a fly fisher. He loved to go fly fishing. I didn't see the point. Anyway, we just never clicked on fly fishing. So maybe you have a fishing rod collection. I talked to a gentleman a year or so ago. He raised his hands and he said, does a Corvette collection count? And I said, sir, I have a charity that I might interest you in. And the answer to that question is yes, kind of. Corvette collection is a little bit beyond typical personal property, but it's essentially those things you own, okay? Your car, your household goods, all right? Your debts and liabilities, okay? Those are also considered personal property, okay? They are an item within your estate that gives somebody a beneficial interest on your estate, okay? Something that is going to have to be paid out of your estate. And all of that comes into the calculation of your total estate value, okay? Your total estate value is all of those assets minus the debts and liabilities. Comes out to the bottom line, okay? Much like it is when we're living, right? We have assets, we have cash, we have stuff in our bank account, and then we have those unfortunate credit card bills that occasionally pop up. How can property be owned? Yes. Yes, if you have have a safe, make sure you're recording, and great thing for the book, okay? Make sure you're recording where that is. Your safe combination, your account passwords, okay? I use a vault, if you want to call it, for all of my online passwords for various things. And my wife is always worried that she's going to lose the master password to get into the vault, okay, and be able to close off all those accounts. All right, property can be owned individually, right? I can own property. My wife can own property. We can own it separately, okay? Now, if you're a married guy, let's be honest, I own this much and she owns that much. All right? I get really happy when she hands me a $5 bill that I can put in my wallet. I have money. So we can own things individually. We own things maritally, okay? As a couple, we own things together. Our house is owned jointly, okay, with both of our names on it. Here in Indiana, you all have a ownership type that is only available to married couples, and that's tenants in the entirety. All right, that's only available to married couples, and it's only available for real estate. All right, everything else is what's known as jointly held with the rights of survivorship. All right, so it's a unique ownership type that is here in Indiana. There's a few other states that use that term as well, but that's a specific term for couples owning real estate, right? And then, so you have joint tenants with survivorship, which says basically I own it together, and then if I pass away, my wife has all of it, okay? And you can do that kind of ownership with anybody else. It doesn't have to be a spouse. All right, so if you have a sibling, maybe you inherit a vacation home from your parents, right? And as siblings, it's joint with survivorship, so that if one of your siblings passes away, the other siblings own it together, okay? And joint with survivorship says that I cannot pass my ownership by will, all right? I have to get the other person's permission to take my name off and put somebody else's name on, which usually isn't done. Usually it's joints with survivorship for a reason, all right? So that's a very specific thing and very different than tenants in common, all right? Tenants in common says that I own it and my brother owns it and we both have pieces of it. He can give his share away to somebody else. I can give my share away to somebody else. And there's not, if he gives his share away, there's nothing I can do about it. All right? That's his share. So understanding that ownership, especially if you go into ownership with somebody who's not related, is really important, because if something happens, there may be an unintended consequence to who becomes owner under their will versus what was understood and expected. All right? So everybody kind of clear on the survivorship versus tenants in common. All right? Because we had some good friends that lived next door to us in Colorado many years ago, and they've since moved to Florida. We often talked about, owning vacation home together, right? That would have been tenants in common, but then they could have gotten rid of their share, and we would have then owned that vacation home with somebody else that maybe we didn't know or didn't like or had, all of those kind of issues. All right, so it can be really important to know how you're going to own things. Yes. Yes.
Anyone on that loan on your track, right? So the non-familial.
Yes. So could that be anybody on a real estate purchase? Is what you're saying? And yes, I mean, you could go tenants in common with anybody on a real estate purchase. Typically, if it's a spouse, you're going to be that tenants in entirety. And that's there's a legal reason for that, and in that definition is this: the state wanted to make sure that a spouse could not be intentionally disinherited. Okay? Now, it doesn't mean that I couldn't own a piece of property with my brother, not with my wife. There is a way to do that. I don't have to own everything with my wife, but if we were going in jointly together, the state wanted to make sure that I couldn't intentionally disinherit my spouse. Okay? All right. Property can be transferred, obviously, by contract, right? We can sell it. We can sell it to somebody else, takes our names off the contract, puts their names on the contract. It can be transferred by deed, and this is where typically you get into that joint tenancy or tenancy by the entirety. The deed says that my wife and I own our house together, joint. In Colorado, it's just joint with rights of survivorship, okay? Which says when I pass away, she gets it, okay? So that's the deed. And then, of course, beneficiary designation. Now, beneficiary designation is generally the document that you will sign when you open a financial account, right? So if you open a bank account, if you open an investment account, if you open a retirement account, they will have you fill out a beneficiary designation form. When you do an investment with Church Extension Plan, we have a beneficiary designation form that we ask you to fill out. That just says, if I pass away, who's going to get that investment? All right? That is a great way to transfer assets outside of the probate process. Okay? The beneficiary designation takes precedence over the will. Because basically what you have done is you have signed a contract with the financial institution that says, when I die, transfer this to that individual. And it takes precedence over the will. So you have to kind of navigate that carefully, because you might think you're transferring something in your will, a particular investment account, for instance, that you want divided amongst your nieces and nephews, when in actual fact, the beneficiary designation on that account says that your sibling gets it. Okay? Now you've just disinherited those nieces and nephews. Yes?
So if I have put my entire beneficiary 100% to my wife, and then she's not here to be the beneficiary, we can go together, then at that point, then does what's in the will kick in?
Yes. So if you have your beneficiary designation as your spouse, okay, and you both die together, and there's no what's called a contingent beneficiary, okay, then that asset becomes part of your probatable estate, okay, because the beneficiary is not there, and so it goes into your probatable estate. Okay, so again, that beneficiary designation, you'll have the primary or primaries, and then you'll have a contingency. So what happens if the first person, passes away before you or at the same time? There's a contingent there that can be designated. Okay, and my parents had this in their estate plan. They had this scenario where my brother, who I mentioned this morning, when he passed away, my parents had set up so that my niece and my nephew were a beneficiary under their estate with a particular asset, okay? And it was just the way they had done the calculation was so that they would get something. Well, my sister-in-law since remarried, and so my parents felt that that no longer was necessary, at least not at the size they were originally going to give, so they changed that beneficiary designation, but they're still on there, okay? And so that's part of the ease of using beneficiary designations is you just go to your bank, you fill out a new form, and it's simple. You don't have to rewrite a will, okay, when that is done. So I'm a huge proponent on using beneficiary designations on financial accounts, all right? Makes everything very, very easy. Okay? And then, of course, the reason you're all here is assets can be transferred by will, all right? You can use your estate plan to transfer assets. And so we'll look at doing that here in a minute. Here is the Indiana intestate succession. Intestate means without a will, without an estate plan. So if you do not have a will in the state of Indiana, this is kind of the basics of how Indiana will distribute your estate. Okay? If you have a spouse and descendants, you may think that your spouse is going to get everything automatically. Well, Indiana says, no, I don't think so. Okay? Indiana says your spouse is only going to get half, and your kids get the other half. All right? So those of you with young kids, if you have a tragic event tomorrow, one of you passes away, the other one, and you don't have a will, okay, your spouse is only going to get half of your estate, and your kids are going to get the other half. And essentially, if they're minors, that half will get held in trust. Okay, so this is a good reason, and why you're here is you want to make sure that your assets are passing according to what you want to have happen. Okay? Now, there's a lot of, how do I put it? You hear the rumblings periodically, okay? And a lot of estate planners or people who do workshops like this will say, plan for your estate, plan your estate so that the state doesn't take your money. Okay? If you die without a will, the state's going to get your money. Not really. Okay? The state is going to work really hard to find an heir. All right? They're not going to just arbitrarily grab your assets and say, okay, well, you died without a will, so now it's ours. All right? That's why they create this process, and they will look for an heir, and they will go pretty deep, okay? Sisters, cousins, nephews, they'll dig pretty deep to try to find somebody to inherit your estate. But if you are of that family situation where, you're, shall I say, the end of the line, it can get difficult. All right? So good that you're here. Good that we're dealing with it. Okay. There are 3 choices on where your estate's going to go. These are choices that you get to make. Okay? Anybody want to guess on what the first one is? Spouse, family. Okay? That's kind of why we're here. We want to make sure family gets our estate. What's the next one? The church? Okay, good. Ideally, ministry is going to be the second. All right? And what's the third? It's the one I just said wasn't going to get your estate. Okay? Ultimately, this is like I said, this is often used to kind of scare people into action, and it's really not that way. Okay? However, there are fees. We saw the probate fees a little while ago. Okay? There are taxes. All right? So we want to make sure that we're planning things so that we minimize that third portion. Can't always get away from it. All right? Really, really large estates, we're not going to get away from it. Okay? Anybody know how much in your estate that you can set aside before the government starts taxing it? There is what they call a tax exemption amount. Anybody guess? It's about 13 million. Okay? Anybody?
What do we do with all of our stuff over that?
Well, that's why we're here.
You want to know that?
That's why we're here, because everybody here has an estate bigger than 13 million. Now, anybody who does have an estate above 13 million, again, I do have a charity. Pastor has a very good charity. I bring that up because for 99.9% of us, the tax issue is not really an issue, right? It's not something that we have to worry about, okay? But we do want to plan. There is one asset that I'll talk about later, that is subject to taxes even in your estate, okay? So we do want to cover that. But in general, most of us do not have an estate tax issue. All right, I want to talk a little bit about that middle box, okay? Supporting ministry can be done very simply, okay? If you're going to do it through your will, you just do a bequest and you say, okay, I want to leave a certain percentage to the church, okay? You might have an asset that's subject to taxes, which again we'll talk about, and you just on that asset, on the beneficiary form, you just designate, I want this percentage to go to Delphi First, and you just put that on your beneficiary form, okay? Make it real easy. And let's be real, okay? This can be your largest gift, all right? Most of us, we have a checking account, might have an investment account, we might have a retirement account, but those are assets that we're using, okay? We still, I'm not saying we give everything away now. We still need a certain amount to put groceries on the table and pay the babysitter, and those of us that don't have grandparents to take care of the kids, we need to do those kind of things, okay? So you can't always give what maybe your heart really wants to do, all right? There are responsibilities and there are certain things, and that's okay. But at death, what do we need the retirement account for anymore? Okay? So this can be a potentially significant gift. And there are lots and lots of ministries out there, and Delphi is one of them, that you've received a large contribution from somebody when they passed away that just was able to bless ministry significantly, okay? And something far more than what you or somebody else might be able to do during your lifetime, right? So that's just something to encourage you to at least consider, wrap your mind around and say, okay, how do I do this? How do I really bless ministry? And we're going to talk about that. We're going to go ahead now and we're going to look at some basic estate plan options, okay? And I alluded to this morning. We're going to look at 3, what I call the basic estate plans, and then a 4th that really has a way of doing something unique, doing something different, and yet taking care of family at the same time. And so the will with a charitable trust is basically, I'm going to show you a way where you're able to give your estate away twice. So you thought you had an estate of $500,000, and I can show you how to give away $1 million. Okay? Sounds like fun, right? Okay. Should I start there? Maybe go? No. We'll build on it. So we're going to start with the simple will. I think most of us are familiar with that, but we'll go through some basic concepts. We'll talk about a will with a trust, okay? And the will with a trust for minors really is for those of you who have minor children and are thinking about how do we set aside our estate in an appropriate way to take care of the kids, make sure they're covered in case something happens to us, all right? We'll talk about a revocable living trust, okay? We had the question earlier about whether a trust kept everything out of probate, all right? We'll look at what a trust looks like and how that is set up. And then we'll look at the will with a charitable trust and go through that whole process of giving your estate away twice. All right, simple will. Basically, you can use your will to make contributions to family, nephews, nieces. You're going to give away, through your will, you're going to give away your personal property. That's usually done in the will. Usually it just says, you know, I want John to receive the gun collection, and I want, you know, Susie to get the Corvette collection, and so on. Okay? Yeah, go Susie, right? So your personal property is dealt with in your will. Any of these estate plans, all of these estate plans, basically assume that you are going to have a will in addition to these other things. All right? The will is the bedrock to your estate plan, and even if you have a trust, you're going to need a will for certain things. All right? You can also, of course, use the will to remember ministry. You can make a bequest. You can use it to, I like to say, use to show your charitable legacy. All right? To say to your family, this is what was important to us. All right? This church was a part of our lives for many, many years, and we want to make sure that we remember that when we pass away. Okay? And then, of course, it can reduce estate taxes if there is an estate tax issue. Again, most of us don't have that issue. All right, how do we make sure our will is valid? Okay? Well, firstly, we have to make sure that we have legal status. Everybody in this room has legal status. You're over the age of 18, okay? You understand what you're doing. You have to have capacity and intent. Basically, I have to know what I'm doing, all right? I intend to write a will. I have capacity to write a will. We have to be free from duress, all right? And what that means, obviously, is that there's nobody pressuring us, okay? Nobody saying we have to do a certain thing or write our will a certain way. And it has to be properly executed, all right? Proper execution means, in general, that it's written up under the state law, the way the state specifies that it has to be written. It has to be signed properly, and it has to be notarized. A will often fail in the probate court because it wasn't signed properly. And usually that happens because, with all good intent, my wife and I, we get our wills drafted, and we go to the notary, and we take along our kids, and we say, we're going to need witnesses, so come along and be our witnesses to our will. And so they sign, and the notary signs, and so on, and we think it's all good. Here's the problem. Our kids are beneficiaries under the will. Okay? So the state looks at that, and they said, aha, your kids were putting you under duress. Okay? Your will fails. Now your estate is without a will. You're now into that intestate succession. Okay? So you want to make sure that you have an uninterested, unrelated, non-beneficiary third party as your signer, as your witness. All right? Freedom from duress. It's usually the duress issue where most wills will get challenged. Okay? There'll really be two. It'll be the duress and the capacity. And usually those two go kind of hand in hand. Okay? One beneficiary will claim that, you know, mom didn't have capacity and that their sibling was forcing mom to do the will this way. Yes, sir?
So if
It'll depend, okay? If your previous copy, or if your current one that was done incorrectly, says in the very first paragraph, it says, this will replaces all previous wills, that old one has been replaced. And even though the signatures aren't valid, it's been replaced, and the court's going to have an issue of saying, we're not sure. Okay? And most wills, when you replace a will, that's mostly what they're going to say is at the top, this is our current will, dated such and such. It replaces all previous wills. So if somebody brings a copy forward that says, I've got this one, well, then this one, has superseded that. Yes, sir? No. Spouse cannot be your witness. Exactly right. And that's the way it would be in our household, too. My spouse is... So, yeah, your spouse, it needs to be unrelated, non-beneficiary individual. Okay? So, how do you structure a bequest in your will? Well, a bequest can be a fixed amount. Okay? You can say in your will, I'm going to give $500 to Delphi First. All right? It could say specific property. Maybe you want to leave a home to a specific person. One of your, one sibling might get the home, another sibling might get the retirement account, however you want to do that. Okay? It can be specific property. It might be a percent of what's called the residual, which basically means everything that's left after the debts and taxes have been paid. Okay? 10%, 20%, 30%, all depending upon how you're dividing it up, all right? And then, of course, it can be a contingent bequest. And the contingent bequest basically says, if for some reason Delphi First is no longer in existence, I want that share to go to someplace, okay? Now, my recommendation would be to not use fixed amounts. Right? Fixed amounts in your will be the first, okay, that'll be listed. I give $500 here, I give $1,000 here, I give $100,000 here, I give $200,000 here. Well, my estate's only $20,000. By the time I die, by the time, the debts and taxes have been paid, my estate is valued at $20,000. Fixed amounts go in sequence. So you may intend for all four people to receive an equal amount, but if the estate doesn't have that much money, the first person may get theirs, the second person may get half, and the third and fourth person don't get anything. Okay? Because all of that changes as we do our will today, and 3 years from now our account values are a different value, a different amount, or we've run up some debt, haven't paid off the mortgage yet, those kind of things, right? So be cautious about using fixed amounts, okay? And you might use a fixed amount and then think, okay, and I'll give everybody else the residuals, and that becomes problematic as well, because remember that fixed amount goes first. And you think you've done percentage on the others, and you think you have a certain amount as the percentage, and it actually has been shrunk down. Okay, so just be cautious about fixed amounts. When my parents were trying to figure out what to do with my niece and nephew, they were originally on fixed amounts, which I tried to advise them against, but that's difficult when you're the son and also an heir and so on. So tiptoeing around those subjects was a lot of fun. But, they wanted a small amount. And I think, honestly, they're still in as fixed amounts. But I think if I remember correctly, what my mom now has done is just specified an amount out of a particular account. So she solved that problem the good way. Okay? Does that make sense? Yep. All right, something to consider. If you have 3 children and you want to do something for ministry, and you're trying to decide, how do I divide this up and how do I create this? Here's a concept to think about and wrap your mind around, and it's really just called thinking of a fourth child, okay? A child named ministry, all right? A child named Delphi First, all right? Where you can say, I want my estate just divided equally, all right? My 3 kids don't need a huge amount. They don't have to inherit a large amount. If they're getting, 25% of my estate, that's not that much left than 33% of my estate, okay? And let's face it, if you have 3 and then you've added a 4th, when you had 3, there had to be somebody who was going to get 34%, and the other 2 were going to get 33%. Who's going to get the extra percent? I don't know, okay? Somebody's going to be upset, okay, that they didn't get the 34%. Okay, so you can specify that 4th child and say, I want this child to receive a benefit from my estate as well, okay? So something to think about, something to walk through and wrestle with and say, okay, God has provided, my kids are taken care of. Yes, I want to remember them, I want to give them something, but I can also do this for ministry as well. Just something to think about. All right, will with a trust for minors. Okay, basically the way this works is your estate is gathered, remember? And everything is calculated, and now we have this amount that is left. And that amount, we specify that we're going to do a few bequests, okay? And so we give away a few bequests, but we take the balance and we say, I'm going to put the balance into trust for the benefit of my kids, all right? And that trust is going to earn income, and it's going to be invested, and it's going to be managed by somebody that you name as a trustee, right? That trustee is going to spin off the income, and they're going to pay to the children or to the children's guardians. They're going to pay an income for a period of time until some point in the future, and then the trust is going to be distributed, all right? All of that wishy-washy stuff, okay? I didn't define how many years, and I didn't define how much income and all of that, because you get to set that in your trust document, okay? It's totally flexible. You can do a lot of different things with that trust document, and so designating all of those, take some thought and take some calculations with the numbers and trying to figure out, okay, if it's invested at this amount and it earns this amount, and how much then are the kids going to get, and so on, okay? There are ways to set it up so that your kids are well cared for. If they've got a medical emergency, things can be taken care of as well, okay? Careful selection of the trustee. Obviously, this is somebody or some entity that you're entrusting with the bulk of your assets, more than likely, all right? So you want to make sure that you're selecting a qualified trustee. Income until the youngest is age, that's up to you. Okay, so if you have, just keep in mind, if you have 4 kids, by the time the youngest kid is age 30, how old is the oldest kid? Okay, so setting those ages is important. Access to principal if needed, right? If there's a medical emergency, maybe you specify when the child goes away to college, starts college of some kind, they get an automatic distribution of, some percentage or an amount, all right? And then after some period of time, the trust is divided up, usually when the youngest, again, reaches a specific age, okay? Yes? So in your will, you will name the guardian of your children. Okay? So you're going to have two people. You're going to have a guardian and you're going to have a trustee. Okay? So here, let me do this here for a second. Let's look at the guardian considerations. Physical custody, okay? Your guardian is the person who's going to take possession, bless their heart, of your kids. All right? Do they have space? Okay? If you're designating a guardian, you have 4 children, and your guardian has a 2-bedroom apartment. Are they going to have the space to take care of your kids? Where are they located? All right? The question becomes, how uprooted are your children going to get? You know, if your guardian choice is all the way across the country, well, that's going to impact your kids, their social lives, their school life, etc. Maybe that's okay. They'll be prepared for it. Okay? I'm a missionary kid. When we were young, this was the issue my parents had. What happens to us kids if something happens to my parents? We're in Kenya. Our closest relative is Bellingham, Washington, way up in the corner. You can't get much further north other than Alaska. Okay? So what's going to happen to us kids? We knew we were going to be uprooted. We knew it was going to be an issue. Okay? And there was a point, my mom was very much, no blood, no bone, no problem, right? Managing healthcare, okay? I was kind of looking forward to being under a guardian. Maybe it wouldn't have been kind of nicer, you know? Those kind of issues you have to wrestle with. The values, okay? Are they going to raise your kids with the same values that you have? All right. So all of those to be wrestled with. Now, we talked a little bit about the trust, the management of the assets, the income that flows, from the trustee and so on. Your trustee and your guardian can be the same person. Okay? But think about it. Just give it some pause and think. Because there's some real temptation when you're handed a pot of money to manage. Okay? And story after story of how important it was for little Johnny, who's 6 years old, to have an 80-inch TV screen down in the basement. Okay? So give careful thought to who's the guardian, who's the trustee. Should they be the same person? Should they not be the same person? And so on. Not saying they can't, and if you can find, very trustworthy people, then that's great. It makes things obviously much simpler. But on the other hand, there is that, temptation factor and so on. So wrestle with that a little bit. All right, let's talk a little bit about the revocable living trust. Okay, property is basically you create this trust document that kind of captures your wishes. And it basically says how your assets are going to be managed if you're gone, how they're going to be distributed if you're gone, and so on. Okay? All of the assets that you have, your house, your financial accounts, and so on. Basically, your major assets, not necessarily your personal property. Okay, so not really your car, not really the china cabinet, those kind of things. Those will still be handled through the will, but all of your other stuff gets retitled into the name of the trust. Okay, and it's then managed by the trustee. Now, while you are alive, you are the trustee. Okay? And you can manage all of those assets. Now, a lot of revocable living trusts can be done as a couple with proper planning, okay, it becomes the Darren and Sharon Revocable Living Trust. Okay? And all of our assets are put into that Revocable Living Trust. We can still, close out accounts. We can still, sell our investments, manage our bank account, those kind of things. But when we die, we have a successor trustee. Okay? The will that you have, and you will still need a will. Any attorney who's going to do a revocable living trust for you will also do a will. Your will is there for two reasons. It's there to capture anything that hasn't been put into the name of the trust and pour it over into the trust. Okay, so for instance, if you've set up your estate, you've done all the documents, and you do that today, and tomorrow your remaining parent passes away and you inherit $30,000. Okay? But 2 days, 3 days from now, you pass away. Okay? Your will, because you're inheriting that $30,000, your estate inherits that $30,000, but the will captures that and pours it into the trust. Okay? It was an asset that you got that you didn't have time to rename into your trust. Okay? So that's why it's called a pour over will. You have those assets that occasionally don't, you don't have time to get retitled, it didn't get retitled properly, whatever. It's transferred over into the trust. All right? And then your trustee does what is specified in the trust document. Okay? It can provide for management. So you can have that trust continue for a period of time and say, my kids, I want to just do some income for my kids for a while and then let them have the balance. Okay, so I don't want to distribute it outright right now. Or you might say, no, I just want to distribute it right now. And so your trustee can distribute according to whatever you put into that trust document. Okay? Again, very, very flexible. All right? It's up to you how you want to design that process, how you want those assets to transfer. You have all sorts of flexibility in doing that, and that's where working with your attorney and sitting down and saying, okay, this is what I want to accomplish. Okay? I want to provide income for my kids for a while, and then I want to distribute it, or I want to just distribute it outright, or, I want to do this or that. You can do all sorts of things with that trust. Okay? But your will, the other part that your will do is not only pour over everything into your trust, but it will take your personal property as well and say, distribute my personal property according to these instructions. Okay? So you will still have the will. Okay, any questions about the revocable trust? It's called revocable because you can change it. You can get rid of it. You can cancel it. All right? There are other estate planning techniques. There are irrevocable trusts, things that can't be changed, can't be undone. Those are, very high level planning in general, but it's called a revocable trust because you can cancel it. All right, here's the biggie. Will with charitable trust. Okay, you have property, and your property is worth $500,000. Okay, remember, these are numbers I've just pulled out of the air, all right? Most of us are probably close, those of us that own a home especially, may be close to having an estate value of $500,000. Okay, our house tends to be a fairly significant part of our estate, and so it can be pretty quickly into that $500,000 range without a whole lot of effort. All right? So hopefully this is reasonably close for a lot of you. I have $500,000. By the time my property is sold, debts and taxes are paid off, and so on, I have designated in my will that I'm going to give bequests of $100,000, and then I'm going to put $400,000 aside into a charitable trust. Now, a charitable trust is one of those irrevocable type of trusts, okay? But in that sense, it doesn't really matter because it's being done after we're dead anyway, so it's not like we're going to revoke it, right? Okay? It's a charitable trust because, okay, charity's involved, right? So in this case, we've set up our property and we've set up this trust. $400,000 is flowing into the trust, and we're going to say, yippee, this is a good thing. And this is then what it looks like. We now have a $400,000 trust. It is going to pay 5% per year for the next 20 years to family. Remember, that trust is got this pocket of money, and it's invested, and it's earning income. We're not going to talk about today's current investment market, please. Just ignore that. But it's invested, okay? And it's going to earn income, all right? It's hopefully going to grow in value, but it's paying out 5% per year. Over time, over that 20-year window, hopefully that trust earns a little bit more than 5% over time. Some years it's going to earn 4%, other years it's going to earn 10%, so on and so forth, right? But over time, hopefully it does well. So as we pay out 5% per year for 20 years, yes, sir? No. Nope. And the reason for that is that, again, it's invested, okay? So if you're invested with a good investment advisor, somebody who's being properly fiduciary with the assets, okay, they're going to invest for the benefit of the trust. And the idea is that the trust is going to grow. But there's no guarantee that it won't lose money in the sense that it may only earn 4% this year, okay? Or it may earn a negative. I mean, how many of us have lost money in our retirement accounts over the last year, right? Okay? That's the nature of the beast and some of the risk, okay? 5% is used because it's kind of the minimum payout of a charitable trust, all right? So that's the minimum payout. It's what's required by law for a charitable trust. But it's also very conservative and very appropriate in the sense that most of the time, on average, you're going to earn 7 to 8%, okay? So there's that up and down, yes. And so your income to family one year may be, the 5%, but on another year it may not be quite as much because it's 5% of the value of the trust on January 1st. All right, so whatever that trust value, it pays out 5% of that during the year. Okay, if the trust goes up, then you get more. If the trust goes down, you get a little bit less. Okay, but let's say it does well. It earns that 5%. 5% times 20 years equals how much? 100%, right? Okay, so my family has now, in 20 years, gotten $400,000. Okay, they've done appropriately. Maybe the trust has grown. Maybe they've gotten more than $400,000. If it's done what it should do over that 20 years, they will have gotten more than $400,000. All right? At the end, because it's a charitable trust, $20 is the maximum length, or 20 years, I'm sorry, is the maximum length. Okay, so 5% is the minimum payout. 20 years is the maximum length. All right, so after 20 years, it distributes to ministry. Okay, in this case, after 20 years, the trust had $400,000. So Delphi First gets $400,000. I gave my family how much? I gave ministry how much? Sounds like a pretty good deal. Okay? remember, we've done the bequests up front. Maybe we did an initial bequest. We gave away $100,000. Maybe we split that between family and ministry as well, 50-50. Okay? So there are ways that you can specify a significant impact to ministry and take care of your family at the same time. Okay? 20 years from now, if you set this up today and that trust went into existence tomorrow, 20 years from now, who knows what great things Delphi is involved in and what an impact that money can have at that time. And again, if it's been appropriately invested, if it's been appropriately managed, it may be more than $400,000. It will hopefully be more than $400,000. Okay? Yes, sir. Okay, in this example, you would probably have a corporate trustee. Okay? So you'll have an investment advisor, somebody who specializes in trust management. There are community foundations that will do that. There are other financial organizations who will do it. We do it, but we do it because usually there's a gift to church extension plan. Okay? So there are organizations who will do it. You do. So in your trust document, you decide who the trustee will be. You would just specify, my trustee selection is this entity. If they're not in existence, then this entity. Usually that's all it takes. There is some risk that those two entities wouldn't exist anymore. And at that point, you would probably give the designation to your executor to specify who the trustee is going to be. You can say, if this organization doesn't exist, then my executor can choose the appropriate trustee. Yes, sir. The money that your family gets will be taxed, yes. It will be a taxable distribution to them. Yeah. Be taxed at their income tax rate. If you leave the house to them outright, is that what you're asking? So if you leave the house to them outright, there should be no tax on that. Outright distributions from your estate should not be taxable, for the most part. Okay? So let's talk a little bit about some other ways that you can support ministry. And I wanted to share this because I know as I was talking with Pastor and he shared the vision with me of what you all have going on here at First Assembly. There's a lot of different ways that you can make what are technically called planned gifts. Okay, planned gifts are usually gifts that are that involve a third party. In other words, you're not just writing a check and handing it off, but it involves either an attorney to draft up a document, somebody to manage funds for a little while, those kind of things. So planned gifts usually take some unique planning. These are some options that are available. A charitable gift annuity is one that community foundations write quite often. We do a little bit of that again. Basically, you make a gift and you get income for your life based on your age. So the older you are, the higher the income is that you will get. Okay? Usually works very well for those of us who are a little bit older in the room. Anybody 70 and above generally will do well with a charitable gift annuity. Okay? It removes that asset from your estate. So again, part of the planning process, it takes that asset, whatever you're using to fund the annuity, takes it out of the estate. You might want to set up your own personal endowment account, depending upon where your estate size is. Maybe you specify and say, I'm going to set up an personal endowment account. I know Pastor has shared that one of the goals that they have here at First Assembly is to create an endowment to really fund the ministries that you all are involved in the community, okay? The endowment fund is a way that you basically are creating a pot of money that is invested, it grows, and it spins off income that funds ministry, no matter who's in charge. So even after Pastor says, the Lord has told me I'm, done in ministry at this point, on to something else, the endowment fund continues, okay? And so it's a great way to set that up. And you can set up a personal endowment as well. Usually they need to be fairly large gifts to set up an endowment. And the endowment can pay the endowment. So it's a great way to do that. Charitable trusts. We just talked about a charitable trust within your will. But you can create a charitable trust during your lifetime. There's a number of different varieties of trusts, different styles, different functions. If you'd like to talk about those, I'm happy to talk about them. Charitable trust can be a really great way to transfer assets. There are some unique things that you can do with those. They provide income for a time period and then a large distribution after the fact. So, great way to transfer appreciated property, avoid some of the capital gains taxation on those assets as well. You can also do a life estate, okay? A life estate is a transfer of a home, usually, that transfers to ministry, but you have the ability to continue to live in the home until you feel like you can't manage it anymore, or until you pass away, okay? And then the ministry becomes the owner of the home. Well, takes possession of the home, okay? It's a transfer. There's charitable calculations in there, charitable deductions that you get to factor in. But that's one way to transfer a home to ministry, but not, force yourself to be homeless, okay? A donor-advised fund. Donor-advised funds are often set up by individuals or families who want to do their charitable giving now, but maybe their charitable distribution in the future, okay? And there are entities that will let you create a donor-advised fund, Schwab, Vanguard, Fidelity, just about you name it, they do it, okay? Basically, you make your gift and you get your charitable income tax deduction this year, and then next year you specify that you want a certain amount to be given to your favorite ministry, okay? So they're great ways that, a lot of, I won't say a lot of, a number of high net worth or middle net worth people think about creating family foundations, for instance. This is a cheap family foundation without some of the same rules and regulations that come into play. All right? So you can create this, again, with an individual entity. Community foundations do donor-advised funds as well. And they're a great way to set that up and then teach your children about giving, okay? You can specify that certain individuals make the giving designations, or you can specify that certain entities receive a gift from that donor-advised fund every year. All right? So again, do your giving now, do your distribution at some point in the future. And you can make that a certain thing after you pass away as well. Qualified charitable distributions. For those of you who have IRAs that you are withdrawing from now, you're retired, and you have the required minimum distributions, okay? That's an amount that, you know, the government says you have to take out of your IRA account every year, all right? The qualified charitable distribution is a way that you can give and still satisfy the RMD and not have that amount counted in your taxable income. Okay? So it doesn't mean you get a tax deduction for the gift, but it's even better than that because the income isn't even counted as taxable income. All right? And it satisfies that RMD requirement. Okay? Does that, everybody kind of tracking? I know not everybody's subject to RMDs yet. I see some young faces up here that, RMD what? Okay? It's coming. It will. Okay? It's only eligible for IRAs, so it only fits with an IRA account. Okay? But it is a way that you can make your gift and satisfy that qualified distribution. Okay? Now, I mentioned earlier that there is an asset that is still taxable when you give it at death. Okay? Normally, your heirs don't pay any taxes when they receive a distribution from your estate. But there is one item that is taxable. It's the wonderful IRA that we just talked about. Okay? So if you're using your qualified charitable distribution, that certainly helps to lower the value of your IRA account. But a lot of people still, they don't need all of that income, and the IRA is well invested, so it's growing more than it's, spinning off in income and so on. So they have large IRAs, and they think, great, I'm going to distribute that to my family. I've named them as beneficiaries on the form. And then your beneficiary says, great, I'm going to get $100,000 out of my mom's $100,000 IRA. And surprise, they actually have to pay tax on it. Okay? Now, this is only for the traditional IRA. It is not the Roth. It's only the traditional. Okay? Remember, when you're doing your contributions into your IRA account on the traditional, you're not paying tax on that money, right? You're getting that tax deduction write-off that's on your taxes. Well, Uncle Sam says at distribution, I want my share, okay? Normally, when you take the income off the IRA, you would pay tax on it. And they said, yep. And when your heirs take the income off of it, they're going to pay tax as well. Okay? So that's the one item. So if you have $100,000, you've made the decision you're going to divide up your estate 50-50. I want my kids to receive half, and I want ministry to receive half. You have a $100,000 IRA account, and you have a $100,000 bank account. Who gets the IRA account? Charity does, right? First Assembly gets the $100,000 IRA account. Your family gets the $100,000 checking account. Okay, because they don't pay tax on the checking account. It's just a distribution. Okay, and because First Assembly is tax exempt, they don't pay tax on that income either. Okay, so keep in mind the asset that you're trying to give away. Personal property. Remember, we talked a little bit about personal property, the jewelry, the silver, the collections, the Corvettes, the fishing poles, the guns, whatever tools, all of those personal items, okay? Usually that's given away through your will. What I suggest you do is that you when you have your attorney draft your will, just ask them to write in, my personal property is distributed according to Schedule A attached to my will. And your Schedule A, you write up on your computer. And you print it out, and you put it with your will. Okay? Then when you give away during your lifetime, you give away the tool collection, say, then you go back into your computer, you take the tool collection off of your Schedule A, you print a new copy, and you put it back with your will. Okay? A very easy way to distribute those assets. Okay? I also want to talk a little bit real quickly about the other important documents that you're going to end up with. Okay? Your estate attorney is going to do a durable power of attorney, which is basically that financial power of attorney we talked about earlier. All right? This will be the document that says that an individual can transact business on your behalf. Okay? That can come into play, say you take a long planned trip overseas and you decide you need somebody to make the house payment, make the utility payment, and so on. Somebody can do that for you. You have the medical power of attorney, which we talked about, that person who's going to make those medical decisions for you. And then you have the advance directives or the living will. Now, my one suggestion is, remember, these are going to just be kind of natural pieces of your estate plan when you work with an attorney, and they'll be part of the package. My suggestion to you is, to the extent that you can, and I realize that families are different and they have different issues and so on, sit down with your family when you choose or when you designate those individuals and talk it through. Don't allow them to be surprised, okay? And if you talk it through, a lot of times that tends to be less of an issue and there's less squabbles that happen than if you don't talk it through, all right? Again, my brother being the empathetic one, he gets the medical side of things. I tend to be more, this, and this, and so I get the financial power side, okay? It's natural for us, and it's what we expected, okay? Have those conversations. It makes it so much easier, all right? Something else to think about, all right? Your estate plan, your documents, really is demonstrating kind of your final stewardship legacy, okay? Your final act, right? And so this is a scripture verse that I came across not too long ago, and really the second part, even when I'm old and gray, do not forsake me, my God, till I declare your power to the next generation. Okay? I get to do that through my estate plan, right? I get to designate and show my charitable legacy, my belief in God's ownership, my stewardship, and declare that to the next generation. It's an opportunity to do that. Along with that, you can write what's called a legacy love letter. This is not a legal document. This is just something you write to your family that basically says, this is why we have done what we have done. Okay? Especially if your family is one that maybe is, shall we say, dysfunctional is probably too strong a word. Okay? Pardon me? Hot mess? Okay. Your family's a hot mess. Okay? There are issues. There are challenges. All right? You can use this. And again, it's part of that charitable legacy demonstration to say, this is what we believe in. This is why we have done what we have done for generations to come. This is why we're supporting ministry. Okay? All right. I've talked a lot. Y'all have been patient. I appreciate that. We've covered biblical stewardship. We've covered property and title and ownership. We've talked about people. We've talked about estate design options. There's been a lot of different stuff that we have covered. And so what I want you to take away really is that the estate planning process, while it seems stressful and while it seems difficult, it actually, in the end, takes away stress. Okay? When my parents were doing their planning, we knew my dad's health wasn't great, And just knowing that their plans were done, that they had said everything, we didn't have to stress over it. We knew it was taken care of, okay? Leave your family with that, okay? Give them that opportunity to not have that stress, to know that everything is taken care of, that they're not going to have to worry about who's going to do what. All right. You have the workbook. So complete that. Use it, please. We hope you'll find it helpful. If you've got questions, I believe my card is in the packet. Please feel free to call me, email me. I'm happy to talk things through, especially on the charitable planning side, on any of those charitable gift types and options and so on. Would be happy to discuss that with you. Work with an attorney. There are some good online resources that you can use as well that tend to be a little bit cheaper maybe than going to an attorney. You can search those out. LegalZoom, Mama Bear, Legal Forms. There's, what's the new one that's been advertised on TV lately? WillAndTrust.com, I think it's called. So there's some good options. They're perfectly legal documents. May take a little bit more to navigate because you're not talking with a person. But get your documents done. If you don't have them, please, 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 get them done. You came for a reason today. Don't waste it. Please don't waste it. And take care of that. Oh, and notify your executor, okay? Don't surprise pastor, okay? I'll get a really bad name in the state of Indiana if you do that. Okay? Make sure you talk to your executor and that they're okay with that process, that they're not surprised that it's coming as well. Well, we lost those links. Sir, you were surprised?
I was the executive.
I'm sorry. And
I know that till after that.
yeah. It wasn't a nice surprise, was it? Yeah. So it takes time away. It's something that you have to be prepared for to do. Okay, just a reminder before you leave, please fill out that card. Fill out that card, please, please, please. Can't beg you enough. Leave that on your chair. That'll help me with any comments you might have. But we're also interested in that information. I'll tell you what happens. The questions 1 and 2, if you fill those out, even if you've left your name, please know that I tabulate these and I will give Pastor the 1 and 2 without your name attached. Okay, I just give him a tabulation that says how many. Okay, so you can still keep your stuff private unless you want me to let him know, and then you can tell me that. But I know a lot of that is kind of personal. But please fill that out, and that will help. And if you're interested in the investments, fill that card out as well, and I'll make sure that a packet is sent to you. So, any other questions? Yes, ma'am. Yeah, kind of, okay? If you're trying to go on Medicaid when you go into a nursing home, okay, there are certain requirements, how much assets you're allowed to have when you go on Medicaid, how long, they do a look-back process, okay? That's an area that's a lot of detail and a lot of if or this or that. I would recommend having a conversation with a good financial planner who understands long-term care planning. That's basically what it's called, okay? And look for kind of how to set that up and navigate that. There are some who would suggest or encourage that you divest yourself of assets as you get closer and closer to the time you think you're going to need to be in there. There are others who think that that's maybe not quite as ethical, And so that's a wrestling question for yourself, but a good financial planner and long-term care specialist would be able to help with that.